Good evening, everyone. I now call upon our President, Mr. C.A. Haresh Kenya, to give the opening remarks.
Thank you. Thank you, Neil. Ladies and gentlemen, esteemed members and our budding student community, I would like to extend my sincere congratulations to our chairperson of the student committee and her dedicated team for their outstanding efforts in organizing this event, the webinar on bridging divides, embracing the Mediation Act 2023. I welcome speaker of today's webinar, Advocate Shruti Desai, true luminary in the legal field with a remarkable track record spanning over 3 decades. This webinar promises to be a pivotal moment for all of us. It will shine a spotlight on the groundbreaking changes introduced by the Mediation Act 2023, a piece of legislation that will transform the landscape of mediation in our country. This act doesn't just refine mediations, it revolutionizes this by making this invaluable profession accessible to a wider range of individuals. Mediation has long been recognized as a powerful and harmonized approach to dispute resolution. However, the Mediation Act 2023 takes it a step further by breaking down barriers and simplifying the process, allowing individuals from the diverse backgrounds, whether they are advocates, CAs, CS, business professionals, counselors, or anyone passionate about conflict resolution, to embark on a fulfilling career as a mediator. One of the most significant aspects of this act is its mandate for mediation as first option in certain civil disputes. This means that understanding the intricacies of mediation has become essential, not only for legal practitioners and mediators, but also for professionals across various sectors. The implications of this legislation are far-reaching and extend to all corners of our professional lives. I encourage each and every one of you to participate in this enlightening webinar. It is an opportunity to gain insight into this transformative act, explore the doors it has opened for us, and understand how it impacts our respective fields. I have no doubt that this event will be instrumental in our collective growth and development. Once again, I congratulate to our student committee for taking the initiative to organize this essential event. Your dedication to our members and legal community is truly commendable, and I look forward to seeing the success of this program. Friends, before we move on to the discussion, I will take 2 minutes to talk about the Chamber of Tax Consultants and its activity for the benefit of many of participants who are new to the Chamber. The Chamber of Tax Consultants is a 98-year-old non-profit organization with 4,000 plus tax experts and students nationwide. Our mission is to foster knowledge, networking, and advocacy in taxation through interactive events and 15 specialized committees. Student education is vital for professional growth, fostering skills, ethics, and collaboration. Our dedicated student committee organizes workshops, study circles, and engaging activities, providing practical insights on topics like audit, GST, and more. We empower students with productive workshops, legal aspects, legal practice courses, competitions, enhancing their training and nurturing their talent. With this, I now hand over the proceeding to Chairperson Niyati to take the proceeding further.
Thank you, Harish Bhai. Friends, once again, welcome to today's session, where our esteemed speaker will be providing us with an overview on the newly enacted Mediation Act. This act is a critical piece of legislation that promises to revolutionize the way disputes are resolved in our legal system. We will delve into its key provisions and implications, helping you gain a comprehensive understanding of its impact on our legal landscape. I would also like to shed some light on the exciting upcoming activities of our Students Committee. Our committee has lined up a series of engaging events and opportunities in the coming months, which includes a session on GST, which will be held either in the last week of November or first week of December. So please subscribe to our social media handle so you all get the updates of all the programs. We are also in the process of organizing a workshop and training in mediation itself. A detailed, it will be an in-depth training session or training course on Mediation Act. So we are also coming in the process of coming up with one. And the highly anticipated Dastur debate competition and the prestigious Dastur essay competition will be held in the months of January or February. So I encourage all students to participate and make the most of these intellectually stimulating events. In addition, we recently published our September edition of the Jigyasa Journal, which is a journal for the students by the students. It can be viewed on the Chamber's websites, and we cover various topics of law, taxation, etc. We are also calling upon talented writers among us to contribute articles for our upcoming December edition of Jignasa. So whoever are interested in contributing articles can write to us, and it undergoes a two-stage process where the student writes under a mentor who helps the student on how to research and write the article, basically provides guidance. And then it is reviewed by a senior professional who is an expert in that field. So all those interested and want their article to be published on our website, please do write to us and contact us, and we'll definitely provide you with that opportunity. With that, we look forward to your active participation in these events and hope that they will be both informative and enriching. Thank you for joining us. With that, I call upon CA Viral Shah, our convener of the committee, to officially introduce our today's speaker.
Thank you, Chairperson sir, and thank you, President sir. Uh, Namaste and good evening, everyone. This is CA Viral Shah here, the convener of the Students Committee with the Chamber of Tax Consultants, and I have the privilege to introduce a seasoned professional with over 30 years of experience in property laws, octroi, stamp duty, municipal laws, arbitration, mediation, and a diverse range of legal fields. Advocate Shruti Desai. She holds a Bachelor of Arts in Economics from the Bombay University, and she also holds a Bachelor of Law from the same institution. She has authored multiple editions of essential legal books, including the Bombay Stamp Act, Mumbai Municipal Corporation Act, Mediation, Path Towards Peace, and many more, becoming an invaluable resource in the field of law. Beyond her scholarly contributions, she has engaged with the public at large through TV interviews, All India Radio, and insightful column in Vyapar, sharing her expertise with a broader audience. We extend a warm welcome to you, madam. It's an honor to have you with us today. I request you to take over and share your valuable insights today on the topic about the Mediation Act 2023. Thank you.
Thank you, Mr. Kenya, Mr. Viral Shah, and Mrs. Niyati Mankar for invitation and giving me this opportunity to speak over the subject. Now, Bridging Divides, Embracing the Mediation Act 2023. Recently, the government has passed an act of mediation. But before coming to the act, we have to first go to the history of mediation. Is it a new concept? It is not at all a new concept for India. Mediation is a very old concept, and it is imbibed in our culture from time immemorial. It has roots in our culture since ancient times of Buddha, Chanakya, Yagnavalkya, and Mahabharata. If you recall, those who are, who have seen the serial of Mahabharata and not read the Mahabharata, Duryodhan was adamant and said he would not give an inch from the Hastinapur. There was a dispute for Hastinapur kingdom, and Duryodhan was adamant and he was not ready to give an inch of Hastinapur to Pandavas. Now Pandavas, they went to Indraprastha, which is now NCR in today's time, and they developed it just like Hastinapur. And then Duryodhan also wanted Indraprastha because it was fully developed. In this dispute, Krishna was a mediator. He tried to avoid the war between Pandavas and Kauravas, but it failed. And then we all know that Mahabharata war took place. In ancient day, now let us come to our family system, Hindu joint family. We had kartas. Like if you have seen, nowadays we have very small families, but in old days, dadas, grandfather, grandmother, they would settle the dispute amongst the various members of the family. Now mukhyas, sarpanch or panchayats, they are also a kind of mediators, and whatever dispute would occur in any village, it would be settled by mukhyas, sarpanch or panchayat head. Even today, there is a Khap Panchayat in UP, Rajasthan, and Bihar, whose judgment and decision is final. Uh, at Gram Panchayat level, also, it is the same. And Gandhiji, of course, he had in those days also promoted Gram Panchayats. People had full respect in those days. People had full respect and faith, and never endeavored to oppose the same. Nowadays, even if a notice of a lawyer goes, they tear it and throw it into the dustbin. Let another one come, then we will see. It was not like that. Every person's decision was honored, and that was the plus point why we had less of disputes in our society. Indian traditions is marked with joint Hindu families where words, sentiments, emotions of all the members of the family are respected, and all the disputes and differences of opinion are settled by the karta of the family, and family remains united. So one of the major factor of unity amongst our family system was the role of elders to settle the differences and disputes amongst the various family members. They have different interests in the family, properties, family business, family issues. So it was handled by only one person, that is head of the family. This was in general the social structure of India, and courts were unknown to our culture. Even as I said today, there is a Khap Panchayat, uh, which is you must have read nowadays during farmers' agitation. There was a Khap Panchayat which said that what to do and what not to do. So uh, uh, next. Now there comes a change in our family system. Now society, there was an invasion by Britishers. This system was hampered to some extent, and the people tended to move to courts by referring dispute to the courts for redressal of their dispute in terms of judgment decree during the British regime. Even today, when there is a fight or a dispute amongst the two parties, देख लेंगे court में, I'll see you in court. But then subsequently what happens, they are not aware of it, because it's in fit of anger, they just give a challenge, see you in court. But I will give you an example. Whenever there is a family dispute and we go with the family dispute in arbitration, suppose there is a family arrangement and property involved is very huge. At that time, during my internship, I had seen Kamani. Kamani group of companies was very rich, and there was a dispute amongst the family members, and ultimately it was shut down, and I have seen the downfall with my own eyes. As a intern to practicing lawyer, I have seen entire his life, and therefore whenever any family matter goes before high court, and brothers are fighting, sisters are fighting, at that time judges from the dais always warns the parties that think over it, don't become kamani. So Why I'm saying this today, because this is the why we promote mediation. We will see in entire this duration of 2 hours that why I said in the opening that don't become kamani, and litigation is it financially makes you insolvent. So this is the best method to settle the dispute. Now, let us go again where we had left, partition and enforcement of the Constitution of India. As we know that in 1947, we divided into two countries and we had our own constitution. At that time also, courts were there, and after enforcement of constitution, cases started piling up. And today, it is more than 7 crores, which is outstanding. And there is a delay in delivering justice and resolving dispute. You cannot say that it is just only one side, that is the bench, and not the bar. Both are responsible, because recently CJI has said that don't come here for just adjournment, come with preparation. And therefore, once again, I will just add to it that if you go to court, civil court, and at 2:30, and there is matters are called out, she has not filed her written statement, she has not filed her reply, I have not been served, no affidavit of service. So the judge is busy doing only administrative work. Where is the hearing? We cannot blame one party. All are responsible for this delay. Now, this delivering and resolving dispute system has really hampered due to the system which is culminated over a period of time. That is last 70 years, from 1947 to today, till today, 2023. Once I was sitting in High Court and I was waiting for my matter to call out. And at that time, suddenly there was, the associate called out one matter, XYZ, notice suit number so-and-so of 1947. So imagine from 1947 to till that date, say 1998 or 2000, how many generations have passed? We don't know, 2, 3. So there is no, there is a say that justice delayed is justice denied. But here, so the people died waiting for the justice. Thoughts in India even today is not much enforced. We, when we read any newspaper of USA, then a person, lady was driving a car and hot coffee fell on her leg and she got crores of rupees of damages. So this is not here. Recently, there was one order of consumer court where a model, she went to have a haircut, and haircut was not done properly, and she lost her account. I mean, the contract was cancelled, and she filed a suit against the parlor of that 5-star hotel, and she was awarded 1 crore. And this matter went up to Supreme Court, and Supreme Court said that let lower court reconsider it. But it was confirmed by the lower court despite of the direction of the Supreme Court. So this was the first judgment which I have seen throughout my life, that at least 1 crore was granted to an upcoming aspiring model who lost her job or the contracts or accounts. Now, it is phenomenal that every human being, when he is lost in a way, goes back to origin. And again, with the same concept, but with improved methods, a new tagline, Indian society is now prepared to go back to resolve the dispute by way of mediation in the name of style alternative dispute resolution. Unlike arbitration, mediation is non-judgmental, and non-binding. Next. Now let us see to whom the Act applies. The Act applies to mediation when it is conducted in India. That is fundamental principle. Law of the land applies. Now, when it is conducted in India, who are the parties? So all or both the parties, they habitually reside in India if it is individual. In case of company or LLP or firm, it is incorporated in India under the Indian laws, or they have a place of business in India. There is now, see, prior to this law coming into force, there was no need of mediation agreement, but it appears now from the provisions of the Act that there should be a mediation agreement. Usually there would be a clause when we were drafting that in case of any dispute, the parties shall first go to mediation. It means that first it will be mediation, and then if it fails, it will go to an arbitration. So under this particular Act of 2023, mediation agreement is must. And I feel from reading of the Act, it is mandatory. Now, then there is also an international mediation which can be conducted here, where both the parties to the one of the parties to the dispute is central government, state government, public agencies, public bodies, corporation or local bodies, including entities controlled or owned by such government, and where the matter pertains to commercial dispute, or to any other kind of dispute if deemed appropriate and notified by the central government or the state government from time to time for resolution through mediation under this Act, wherein government or agencies, public bodies, corporations, and local bodies, including entities controlled or owned by them, is a party. At that time, mediation can be conducted in India. Now, who can be a mediator? There is no specific provision in the Act about who cannot be a mediator. That means the definition is inclusive and not exclusive. But in section 3(1), it is provided that mediator means a person who is appointed to be a mediator by the parties or by a mediation service provider to undertake mediation, and includes a person registered as a mediator with the council. So one thing is there that anyone can can be a mediator, but he should be a trained mediator. Unless he knows the nuances and the system and the process of mediation, he will not be able to conduct your mediation. So mediation can be any person. And mediation service provider. Now, mediation service provider rules and provisions are under consideration, and it is at draft stage. So I will not speak much on this mediation service provider, but it is on the lines of arbitration service providers. So similarly, I think IMC has, Bombay Merchant Chamber has, and many other institution has such service. They provide service of mediation at a very considerable or a very, you can afford affordable rates. Now, basically, he should be a trained mediator. In Bombay High Court, if you are a practitioner in Bombay and you have passed any certificate course, even if you are a CA, you can register yourself with the Bombay High Court MPanel. There is a mediation center in the annex building, and you can send with your certification, and there is a form which is available to the in the mediation center, and you can enroll yourself as a mediator on the on the panel of the Bombay High Court. Those who are practicing in Delhi, Delhi is one of the best mediation center, and they are doing very good. And there also you can, if you are in Delhi, you can, and various other institutions are there, like stock exchanges there, NSCA there. You can, if you are a certified mediator, you can register yourself as a mediator, and then, courts will appoint you as a mediator, and pursuant thereto, you have to act as a mediator in a particular matter. Now, how many mediators are there? Usually only one, because if there is more than one, there are chances of differences of opinion, because every person has its own individual thought process and decision making methods. So it is advisable to have only one mediator. But if a matter is of national importance, then there can be more than one mediator. We have seen in case of Ram Janmabhoomi, there were more than one mediator. I think three. One was a retired Supreme Court judge, and other two were there. Next. Now, we studied about the history and who can be a mediator, how to enroll yourself as a mediator. Now, suppose the matter comes to you and you are appointed as a mediator. So how it starts? A mediation agreement, first and foremost, there has to be a mediation agreement by and between the parties. It can be by way of an order. Suppose your matter comes before the court, and you agree for a mediation, and court passes the order. So mediation starts from the date of the order. And mediation agreement may be, what should be the form of the mediation agreement? There is no such defined form, but there has to be a contract in writing. It can be by way of a letter, exchange of letter, or emails, and pleadings. As I said, any pleadings in a suit, or any proceedings which is in existence, where there is a provision of mediation. Even if today your matter is pending before the court, and you say that, lordships, I want to go for mediation, you will be given a chance to settle the matter of your own. And courts will be, they will welcome you to settle rather than to contest. So what are the, how mediation starts, and what is the necessity to start a mediation? There has to be an agreement in writing between the parties, and they have to submit their mediation certain disputes. Now, what is the when the mediation starts? So first criteria is there has to be some dispute, and mostly it is nowadays matrimonial disputes and property disputes. Commercial disputes are there, but majority of disputes are matrimonial disputes. So now requirement is there has to be a pre-existing dispute. There has to be an agreement, mediation agreement. It should be in writing. There is no form like will. There is no form provided in the law, but it should be in writing, signed by both the parties. It can be communication of letters in exchange of email by the advocates or by the parties. And pleadings in any suit or other proceedings in which existence of a mediation agreement is alleged by one party and denied by the other. So these are the requirements to start a mediation. Now, reference in any agreement containing a mediation clause shall constitute a mediation agreement if the agreement is in writing and the reference is such as to make the mediation clause as party of that agreement. The parties may agree to submit to mediation any dispute arising between them under an agreement, whether entered prior to the arising of the dispute or subsequent. So, as I said, that if your matter is pending before the court, despite of that, you can go for a mediation. You can inform the court that now we don't want to contest at present. We will try to settle our dispute through mediation, process of mediation. A mediation agreement in case of an international mediation shall refer to an agreement for resolution in matters of commercial disputes referred to clause A of section 3. This is provided in section 3, clause A, where international mediation can be referred to and mediation. Now, as I said, the court can refer the matter to the mediator at any stage of the dispute, provided there is no decree passed. Now, types of mediation. It is first one is court and its mediation. Means mediation including, which includes pre-litigation mediation conducted at the mediation centers established by the court or a tribunal. As I said, in Mumbai, there is a Bombay High Court has a place to conduct mediation. You have to first book the slot and they will arrange for you. Institutional mediation, I think in Mumbai we had one institution of arbitration. Institutional mediation has not started yet because the rules and regulations is at draft stage. So it has not started, but it will start soon. International mediation means now under this act and relates to a commercial dispute arising out of a legal relationship, contractual or otherwise, under any law for the time being in force in India, and where at least one of the party is an individual who is a national of or habitually resides in any other country other than India. So this is international mediation or any body corporate, including a limited liability LLP of nature with its place of business outside India, or an AOP of individuals whose place of business is outside India and the government of a foreign country. Now here I will just give you an example of a mediation when there was nothing like this. Even CPC was not amended. One of the business houses, brothers, Ambani brothers, Reliance Industries, they separated by way of a mediation, the two brothers. So this was Mr. Kamath at that time, he succeeded in settling the dispute. And today we see how, the company is growing and both the families are enjoying their life instead of wasting their time in the court. Next. Now, there is also a concept of community mediation, which is provided in section 43 of the 2023 Act. Now, what is community mediation? I will tell you. First, we will see what is the provision. Any dispute likely to affect the peace and harmony and tranquility amongst the residents and families of any area or a locality, they are settled through community mediation with prior mutual consent of the parties to the dispute. So there is some, very, you can say, sensitive issue between the two communities, and police usually tries to, settle the matter by way of a mediation instead of using the force and filing FIR, arrest and all. Now, for the purpose of this section, any of the parties shall make an application before the concern. Now, this is the procedure which is provided for community mediation in section 43 itself. It says that for the purpose of subsection 1, any of the parties shall make an application before the concerned authorities constituted under the Legal Service Authorities Act 1987 or district magistrate or subdivisional magistrate in areas where no such authority has been constituted for the referring the dispute mediation. In order to facilitate settlement of dispute for which an application has to be received under subsection 2, the concerned authority constituted under the Legal Services Authorities Act 1987 or district magistrate or subdivisional magistrate, as the case may be, shall constitute panel of 3 community mediators. And another requirement is, for purpose of this section, the authority or district manager or subdivisional magistrate, as the case may be, shall notify a permanent panel of community mediators, which may be revised from time to time. So there are certain areas where the government feels that we need a permanent mediators to keep the area cool. So they have community mediators. There are another communities like Parsis. They have their own panchayats, Parsi panchayat. They don't go outside. Even their matrimonial cases, they decide, and only appeal comes to the High Court. Similarly, there are certain another communities of Marwadis. They have their own community mediations, and they settle their differences within the community itself. So we still have those old system in place, and it is functioning successfully. Now, in who can be included in the panel referred to in subsection 4 in community mediation, which said that there should be permanent panel. So persons of standing integrity who are respectable in the community, any local person whose contribution to the society has been recognized, representative of the area or resident welfare association, person having experience in the field of mediation, and any other person deemed appropriate. So a person who is connected to the grassroots level can be appointed in the panel of permanent mediation. Now, while making a panel referred herein in subsection 4, the representation of women or any other class or category of person may be considered. So if a woman wants its resolve her issues, there has to be a woman member in the permanent panel of the mediation. Now, procedure for community mediation is provided in section 44. Any community mediation shall be conducted by the panel of 3 community mediators, which is provided in section 43, who shall devise suitable procedure for purpose of resolving the dispute. The community mediators shall endeavor to resolve the dispute through community mediation and provide assistance to the parties for resolving disputes amicably. In every case where a settlement agreement is arrived at through community mediation under this act, the same may be reduced into writing with the signatures of the party and authenticated by the community mediators, a copy of which would be provided to the parties. And in cases where there is no settlement agreement is arrived, a non-settlement report may be submitted by the community mediators to the authority or the district magistrate or the divisional magistrate, as the case may be, and to the parties. Any settlement agreement arrived at under this chapter shall be for the purpose of maintaining peace, harmony, tranquility amongst the residents or families of any area or locality. Shall not be enforceable as a judgment or a decree, but it is voluntary. It is voluntarily decided by 2 communities there are certain areas, even in Mumbai, where the one person starts prayers earlier than the another religion to accommodate each other. So it still prevails here in India to not much of we don't have much of disturbance and problems. The provisions of Section 20 shall mutatis mutandis apply in relation to registration and mediated settlement agreement under this section. So it is whatever the provisions of registration is there, it has to be, as I say, it is provided, it has to be submitted to district magistrate. Now, territorial jurisdiction to undertake mediation, which is very important. Because many times, matters are transferred from Gujarat to Maharashtra and Maharashtra to some other Rajasthan. I saw one matter where Murthy was taken from Gujarat to Rajasthan and petition was filed in Mumbai High Court, which was then Bombay High Court said go to appropriate court. So this is what is very important, territorial jurisdiction. Behind, on the reverse of the bill of exchange, those who are, olden days, we used to see on the backside of the bill of exchange, they write subject to jurisdiction of Mumbai, subject to jurisdiction of Delhi, Calcutta, and so on. So territorial jurisdiction is very important. And before starting the mediation, one should first confirm the territorial jurisdiction. Every mediation under this Act shall be undertaken within the territorial jurisdiction of court or tribunal of competent jurisdiction to decide the subject matter of the dispute, provided that now there is a provision. Now, suppose they have said that it is subject to the jurisdiction of Gujarat, but now there is a mutual understanding between the parties. With that mutual understanding of the parties, mediation jurisdiction can be changed to Maharashtra, Mumbai. So now what it is provided in the Act? It is provided that on mutual consent of the parties, mediation may be conducted at any place outside the territorial jurisdiction of the court or tribunal, or by way of online mediation, like how we are studying now online. So it is permissible. For there is an explanation to this section that for the removal of doubts, it is clarified that where the parties agree to conduct a mediation at the place outside the territorial jurisdiction or online for the purposes of enforcement, challenge and registration of mediated settlement agreement, the same shall be deemed to have been undertaken within the territorial jurisdiction of the court or tribunal or a competent. Because once you say that I submit to a jurisdiction, you cannot retract. So once you have submitted that jurisdiction will be Delhi, you cannot say, no, there is a provision in the agreement, the jurisdiction is Mumbai. So that is not permissible. What is the first thing to start a mediation or any litigation? The first thing is there should be an existing conflict. Now, why does the conflict arise? Ask yourself. Three W's: wine, woman, and wealth. Check any litigation. The origin of the dispute or a crime is wine, woman, and wealth. Now, in Gujarati, there is a say, jar jamin ane joru, trane kajyana choru. So, jar is jewelry and money. Jamin is property, immovable property, and joru, that is the better half. Three things are there which originates any dispute. This is a very old say, so I am not adding anything of mine. Now, why there is a conflict? In a family, one person is dominating, say a husband or a wife. So the one who is not dominating and submits to the domination, that person, he is her king, queen, whoever it is, their emotions are uh, suppressed, and like anger, frustration, it culminates into anger and frustration over a period of time. So one feels they are being threatened, their identity is lost. The person is just, nowadays people say, using me. So it is nothing like that, but then it is a feeling, or because the other person doesn't understand the feeling and the thought process of uh, the person who is suppressed. So it goes on suppressing, and in our Hindi, the more you suppress, more there is bounce back. So this is one of the reason of a conflict. So before it takes a huge shape of a litigation or a dispute or a war, one must understand and conciliate or resolve, or you compromise with the situation. Now, no, the previous one. Uh, now, war. Nowadays, it's an era of war. So why there is war? First war was between Ukraine and Russia. This is my, independent. I'm not trying to judge or anything, but there was an issue and agreement between Russia and Ukraine that Ukraine will not install any, defense base or enter into NATO. And that mistake was done by Ukraine, and Russia tried to stop them. But the Ukraine was adamant to join NATO, and Russia started a war. This was the main reason why Russia and Ukraine war started, and it is unending. At present, Ukraine is as we see that European Union have said that we cannot add you as our member, and the Ukrainian have lost their life, their children are destitute. If we also migrate somewhere, we feel, or we remember our own country, our homeland, and we miss our people. So you just imagine how a small kid who had to leave Ukraine and stay somewhere else must be feeling. Now, Israel and Hamas. This war is going on since last 70 years, but the attack which was done in a traumatized manner on the civilians, children, and females, it was unbearable for Israel to, compromise. So there is a war. So the ladder, if you see, I've given in the disagreement. So Russia, Ukraine, I explained that there was a disagreement, that though there was an contract or an agreement duly signed by the Ukraine government with Russia, still they said that NATO will, install their military base on the, borders of the Russia, and the war started. So there is first disagreement, then it is a polarization. One person takes a stand. Ukraine said that, no, I will join. And Russia said, how you can join? You have agreed that you will not join. Then there is an impasse, there is a communication loss. Then both of them will, I'm right. They will use their tactic to prove self that I am always right. There is a loss of contact, and threats become strategic. There is harmful blows, and subsequently there is a destruction and abyss. So this is how the war started. Had is Hamas is a terrorist organization. Palestine would have controlled it, not to fund them. This day wouldn't have come. Similarly, Ukraine would have not so adamant to join NATO. There wouldn't have been war. War is not good for humanity, and many families, children, women, they suffer a lot. And if it goes on more and more, there may be a crisis, food crisis, water crisis, environment crisis, and of course, in that particular region, there may not, either there will be more of rains or it will be a drought. So it is not good for humankind. So there were, all the countries head are trying to settle. We see that heads of the country, they meet together and they try to settle the issue, but this is now has become a very complicated. So before anything goes up to abyss, you have to settle down the disagreement stage itself, and at that time only they should have gone to UN to settle the dispute uh, regarding whether it is Ukraine, Russia, Israel, or Hamas. Next. Now, see, we are into a development stage, and from uh, developing country to a certain level of development has occurred in last 10 years. So while development, see, I'll tell you example. In Gujarat, Narmada Sardar Sarovar Nigam was established and launched by Pandit Jawaharlal Nehru in 1950. He laid the stone of Sardar Sarovar Nigam in 1950. From 1950 to 2000, 2010, I think, 2010, it took so many years, 60 to 70 years. And the equity, social and justice, I'm just saying that what is the development conflict? How government, faces the development conflict. Even if they want to develop a country or a region, how difficult it is. Now, Narmada is shared between Gujarat and Madhya Pradesh. So there was first dispute between the two states, and so, there was also an agitation, Narmada Bachao agitation by one of the activists, and she usually used to be on fast, and she said that Gujarat will be submerged if the dam collapses. You cannot go beyond a certain height, and whatnot. And international people, they started funding it. Yes, yes, no, you cannot have this Narmada dam. See, she was fighting for 600 Adivasis whose land would have submerged in this project of Narmada. But if you see, since I'm from Gujarat and I used to travel, every year, and I've spent my childhood over there, I know the change and the development now. And if you see, for 600 to 700 families who would have lost their land, and government was giving them a settlement option, but for a reason unknown, 5 crores of Gujaratis, they remained without water. There were riots in Rajkot when one of the IAS officer was transferred, who was very good, and who provided, if you go even in the night, sir, there is no water, he would arrange. This was the situation. And Rajkot today, the present government has brought the river from Kutch. One of the river, it had gone silent somewhere, and it was found out, Saraswati, and it was joined, and now Rajkot Bhadar Dam is connected from Kutch to Rajkot, and now there is no problem, and even they get rains. For 25 years, there was no rain. Similarly, Sabarmati River, it was a stinking zone of Gujarat, and you could not even train passes through Sabarmati, river. You would feel that Ahmedabad has come. If you the sewage was not there, electricity was not consistent, and now there is 24 hours electricity. There is a water. Only thing was Narmada Dam. If there is no water, there is no life, and if there is no life, there is no development and no investment. Yeah, there is one more, interesting case has happened. Singur land. How the politicians and society suffer. It is one of the best examples. Singur was where the Tata Nano plant would have come, and huge acres of land. Tata had done a lot of investment over there. And because of opposition by current government chief minister, at the time she was an opposition leader, and the CPM was a very traditional leftist government, but democratically elected government. They thought that now West Bengal needs factories and local employment. So they sanctioned Tata Nano. But because some of the land, she said that it's a family land, and matter went up to Supreme Court. Supreme Court said you return the land. So Tata decided to shift. At that time, options were there: Karnataka, Rajasthan, Maharashtra, but Gujarat succeeded in getting Tata Nano in Sanand. What happened thereafter? Sanand is now at present a developed village. It is now virtually civilized, developed, not only village, but you can say metro. Again, I will say Statue of Unity. There was a conflict. Statue of Unity, now where it is standing, it was a barren land and Adivasi land, and there was no employment opportunity. At present, if you go and see, all local people are getting employment. There is a region is full with, hotels are coming up, and many other employment opportunities like cab drivers, then chai wala, and so many employment opportunities has come. Similarly, here in Mumbai, there was opposition by environment activists that metro car shed. So there also is reason. So the thing is, whenever government takes step to develop a region, and there is an opposition, it costs a lot to the nation, and the society suffers and remains backward. So mediation is one of the best method where we can go and settle all such disputes, so that environmental issues are also addressed, and also that the region is developed. Now this is the model which is designed by Clock and Goldsmith. It is interesting graphic. It speaks volumes to one of the picture. Now what it says, we are studying conflict iceberg, a model that shows issues, personalities, and emotions on the surface. However, underneath all that are values, interests, needs, expectations, etc. It is not so much about the conflict itself, but what we are bringing here is the conflict. Patience is required to find out what is going on beneath the surface. Now see, unresolved issues from the past. That is, there is a baggage. between husband and wife, or brother and sister, or sister and sister, or whatever it is, the relation, two corporations, two companies, two partners. Now there is hidden expectation. No, that triangle. There are hidden expectations between the parties, that one should do this, another should do this. Then there is self-perception and self-esteem. There is a, someone says that my self-esteem is damaged, or you have hurt my self-esteem, I have self-perceptions about you. Then interest, needs, and desires. A mediator must find out why there is a dispute. What is the interest, need, and desire, and which is not fulfilled or not given, which has led to this dispute. The emotions are hurt, as we saw at the beginning, that mediation is, our society is basically emotional. We are bonded with our family and friends. So emotion is hurt, then it is very difficult to, collaborate once again, to rejoin. But yes, we can try our level best to, console the damages. And there are personalities which is damaged, and all these issues are, the mediator has to take into consideration before arriving at a final process of making them understand that what exactly it is. Now it is mediator's job to remove all these blocks, the baggages, what he's carrying, that we saw in the diagram, and find out what is going on beneath the surface of each party. What is going through mind? Mind cannot be read. I can say, oh, I'm so happy, but I'm not. Or I'm, I'm not, I'm sad, but I'm happy within. So if there are many, I mean, I can say that uska kharab hua. Oh, वैसे तो मुझे अच्छा लगा, अरे no 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 no, very bad. So this happens. It's nothing new. So unless otherwise agreed upon by the no previous, it is mediator's job to remove the blocks. This is a simple way of explaining what diagram we saw previously in a triangle. Someone's emotions, we may only see the anger on the surface, but if you see as a mediator, can bear in mind that this person obviously has a need to do something of the interest to them and need to be aired and resolved. Going into any conflict situation in the future, I would consider the iceberg model to be the great part of seeing the beyond the issue, thus helping you not react immediately. Mediator should not react immediately. Now, in such case, mediator has to play his role, and which is very important. Now, appointment of mediators. Unless otherwise agreed by the parties, a person of any nationality may be a mediator, provided that the mediator of any foreign nationality shall possess such qualification and experience, accreditation as may be specified. The parties shall be free to agree upon the name of mediator and procedure for their appointment. If the parties do not reach to any agreement, then the party seeking intimation of mediation shall make an application to mediation service provider for appointment of, if since mediation service provider is not there and your matter is before the court, you can apply to the court for appointment of a mediator. So what happens upon receiving the application? Mediation service provider or the court within period of 7 days appoints a mediator as agreed by the parties. Either there is a name given or there is no agreement on the name. The service provider would appoint a mediator. and the appointment must be communicated, and otherwise within period of 7 days from the date of receipt of the communication. No, mediator must agree within 7 days from the date of proposal to mediate in the matter. What is the time period under the Act of 2023? It is 120 days from the date of appointment. And in case of court annexed mediation, it can be extended by another 60 days by an order. You have to apply to the court. And if it is not court annexed mediation, it may be by mutual agreement, but in any case, it cannot be extended for more than 60 days. And after 120 plus 60 days, if it is settled, then other procedure. If it is not settled, a failed mediation report is filed. Now, conduct of mediation or process of mediation. Mediation is a process where neutral third party who is a mediator and the parties to the dispute come together to resolve their disputes and differences of opinion in the meetings of mind. Neutral mediator never imposes his decision, but he is a communicator. He endeavors to resolve the dispute between the parties to arrive at an amicable solution. It is our tradition to forget and forgive as well as to give and take. Taking this norm as substratum of the mediation process, a mediator is conduit pipe for both parties to settle their misunderstanding and disputes by forget and forgive, and give and take, arrive win-win situation. So this is a voluntary process, and mediator will not suggest anything. And we will see now next. All the communication between the parties will have to pass through the mediator, but as a stage comes with the efforts of the mediator, the block hindrances and differences between the parties are broken, melted, and parties during the process of mediation start communicating with each other. And that is the success of the mediator's efforts to break the ice between the parties. And thereafter, only there could be an amicable settlement. I will show you subsequently the next slides how it is done, how the impasse or hindrances or baggages are broken. Now, first we will see the role of a mediator. He should consider during the process that arguing over positions produces unwise agreement, and the same time is inefficient, which may damage even the ongoing relationship of the parties. However, the mediator should take care that when the stage of bargaining comes, during the process, he should monitor the process which may develop into cooperative bargaining or principled bargaining, which is also known as collaborative bargaining. There are many impediments to settlement despite of the fact that a mediator is a trained and qualified person having integrity, which may be due to failure of communication, poor negotiation skills, lack of sufficient information, inability to control emotions, differing legal perspective, unrealistic expectation, and most rigid impediment to settlement is there are wrong people on the table. So mediator has to handle all this, to come to a positive solution to a given problem. See, this is a court scene. Here you can see the honorable judge. Here you see the attorneys arguing on behalf of their clients. These are the litigants, clients. So now what happens? Mediation is a path to achieve a settlement. When person approaches a court, his psychological, economic, and social life is in a disturbed state of mind. Your emotional, emotions, ups and downs are part of a litigation. Sometimes you feel that you are going to win, sometimes you feel that you are going to lose. So that insecurity is always hooding over the litigant. Nowadays, the litigation also requires a lot of money per day, per appearance, there are charges. And as far as the Indian judicial system, it takes a suit to come for a final hearing, nearly 25 years, that is one generation. And there are news also that after 70 years, a suit, 90 years, it came into the newspaper regarding one of the some property was acquired during war and it was given now. So there is a delay, of course. By the time the suit comes up for hearing, either party is dead or the cause of action has lost its strength. Therefore, reduce the burden on the judiciary, the system of mediation is going to be introduced. It is already introduced. It is duty of the mediator to arrive at direct the parties to come at amicable solution to the given problem. Now, as I said in the picture, it is seen that the parties to the litigation are playing silent role by sitting on the backside, and on the contrary, their future, their interest is in the hands of attorneys who are appearing for them here. The involvement of the parties in the process is just to briefing the counsel, and counsel argues on their behalf, and they are silent when the matter is argued, and they are the spectators. Now, very first session of a mediation is a joint session in which mediator, both the parties, usually it is advisable not to keep advocates in the joint session even. So it is advisable not to keep advocates present. So mediator's attitude, composure. Now, what is a joint session and how mediator should posture and conduct? So the mediator should not make any haste, because haste results into waste. A mediator must constantly think. He should think pros and cons and effects of every action and possibilities of reaction. The mediator should ask more and more questions to gather the facts. A smile generates a positive aura, and it's like smiling doctor heals 90% of the disease of a patient. Similarly, if a mediator has a smiling face, it evaporates 90% of the hatred and generates some extent of positive attitude, establishes contact with the parties to the mediation. The mediator must be confident and optimistic. So if you are going to be a mediator, you should take care of how your attitude and your perception, your act, and your body language should be. Body language is very important. One has to learn, and it is a very important thing in a mediation. We will see by way of a few pictures at the end of this lecture what is body language and how you should analyze. Now, we saw that what should be the attitude and composure and conduct of a mediator. A mediator must, before winding up, ask. So if your joint session is going to end, mediator must ask that whether there is anything more to say, anything issues you have left out, or something that is remained to be disclosed or discussed, is please tell me. So please note that even minor sentences in the mediation may be important and give a clue to reach an amicable solution. So this is how the mediator has to conduct himself in a joint session. Now, in an introductory meeting, in this, all the parties, including the mediator, introduces himself. And a short narration, parties give a short narration of the dispute is discussed in the joint meeting. The mediator scans through the problems and condenses it in a manner by which it has been reduced to certain issues between the parties. I mean, you have a lot of things, but then issues may be 2 or 3, like how we frame issues in a suit. It is the duty of the mediation to confirm those issues with the respective parties. So the first arrangement of the meeting is party, advocate or a counsel, then another party, advocate or a counsel, and mediator is in the center. So mediator is sitting here and the parties and the advocates are here. And usually you should ask questions more to parties rather than the advocates. And let them speak themselves and advocate just to help them and guide them. So this is the first arrangement of the meeting of a joint session. Now, caucuses. Caucuses is private meetings between the two parties. So when your first session is over, you have understood and you have condensed the dispute to the issues. Now, what you feel is there are certain things which I need to talk to personal level, and other parties present you don't require. You should book 2 rooms when there is caucuses. So you make them sit in the adjoining room and keep on shunting between two rooms. And you ask first whoever takes a volunteer, or you ask the first person whom to ask first in caucus. So a person volunteers, you go and ask questions in your mind. See that it is private, and discussions are held in such meetings shall remain confidential. You need not tell this to the other party. The only material that is to be shown to the other party, like documentary evidence or any other oral information, is a duty of the mediator to take permission from the other party to disclose the same in a private meeting to the other party. So if I'm into a caucus, that is a private meeting. So first I go to this lady and I ask, ma'am, what is this issue? What you have to say? What is the reality? So she will give me documents. And then before going to him, I have to ask her, ma'am, can I show this document to him? If she says yes, then of course you can show. And if she says no, it is the duty of the mediator to think of a via media. So permission is must. Mind well, entire mediation process, there is nothing in writing. It is on trust. And it's an oral system of settling the matter. Like in a court, we have briefs and arguments and arguments. Here, no. Here, evidence is provided, and the mediator is trying to settle the matter. It's an oral system of resolving a dispute. But when there is a documentary evidence, it is furnished to a mediator. He or she should take permission of that person that should I show it to the other party. If permission is granted, you can ask questions on such evidence, documentary or the oral, to the other party here who is sitting on the adjoining room. And then what you have to do, you have to put him to the question. If he breaks down, he will answer your questions, and then again you go to her and inform her that his reply is this. Then you will come to know that exactly what is the situation, because either you have an documentary evidence or their oral references or submissions. So then next there is a joint. So when you have booked the 2 rooms, You can shift it to the any one of the larger room. It should be on the same day. See, you should not waste time. If you feel that the boiling point is now reducing, the internal uh, you can say the frustration has come out, and you should not prolong the mediation, and immediately you should shift to another room where all the parties are there along with you and start negotiation. Because in caucus you got an idea, documentary or oral, and the other party has broken, and now there is immediately a joint meeting between the two parties, and you discuss as a mediator that this is what is the problem, and uh, it is diluted between the parties, and they arrive at a negotiated settlement, and terms arrived at between the parties are to be reduced in writing, which is to be signed by both the parties and the mediator. This is a short summary of a mediation. I mean, without wasting time, because once a party goes out of the room and goes home, there are many advisors. So, without wasting time, if you feel that there are chances of a settlement, then you must, first settle the matter and reduce the terms into writing. If it is signed, and then you keep that the settlement points with you, and this is the short summary of the mediation process. Now, how in the second mediation meeting, here is the mediator, here is the party, and there is a final negotiation. So first is joint meeting. You introduce yourself as a mediator, and how to behave and how to conduct, I explained to you. Then there is caucus, that is private, meetings. And after in the private meeting, if you get to know the real crux of the problem, you immediately join them and ask them to sign right terms of settlement,
Uh,
and make all the parties sign.
Shruti ma'am, one participant has raised question. Can we
Yeah,
announce? Now?
yeah. 1 minute. Just my battery is down.
Soham, you may ask your question. You'll have to unmute your mic.
Sure, ma'am. Thank you. Am I clearly audible?
Yes, yes.
Yes. So my question was, if two parties enter into a contract which has an arbitration clause, and the clause also includes pre-mediation clause, pre-arbitration mediation clause. So if the parties, in case there arises a dispute and the parties decide to go for arbitration directly, would any settlement reached through that arbitration or any award reached given by the arbitrator be legal? Another question is, if there are two separate clauses
Soham, just hold on.
regarding
Hold on.
sorry.
Just hold on for for a minute.
Yes, ma'am.
Yeah.
Shruti, am I able to hear us?
Yeah.
Yeah, so
So his first question is if there is a provision for mediation and arbitration. So it depends upon the language of that particular clause. If there is written that it is written that first parties will go to mediation, then you have to first go to a mediation.
Thank you, ma'am. And another question, which is a kind of a follow-up to that, is that if there is no clarity over whether the pre-arbitration mediation is mandatory or there are two separate clauses, and we have to construct them, look at their construction to decide whether pre-arbitration mediation is compulsory or not. How do we do that?
In commercial, I will come to that aspect is there at the tail end of this lecture, but anyhow, since you have asked me the question, I'll just answer that as far as commercial suits are concerned, it is mandatory. And I will also discuss the Supreme Court judgment where parties, what they do, that there is an urgency and they just go and take an injunction, interim and ad interim injunction from the court. So Supreme Court has now taken cognizance of this attitude and the behavior of the parties and have directed that check whether the institution suit mediation is they have not just bypassed for a reason. So this the problem is in India, like unlike the other countries, we do not have a penalty. There are so many things missing from this act, but we do not have penalty system, and it is still a voluntary. And if there is a provision for heavy penalty, and suppose the plaintiff or the defendant says that I'm not agreeing to mediation, I'll see you in the court. So if there is a heavy penalty, such attitude will reduce, but it is still we are at a nascent stage. So pre-litigation mediation is mandatory in commercial suits, and you cannot bypass them. And maybe Supreme Court will come out with a judgment and the guidelines very soon. I will discuss that at the bottom of this lecture about the
So, ma'am, thanks a lot. That was helpful.
So this is a final meeting situation. He is a mediator, party, negotiation. Advocates and counsels are in the corner and agreement. Usually what happens that, why I said that immediately you should agree, make them write the minutes and the terms of settlement, because they change their mind. If they go home and there are advisors, why you have agreed? It is so less. Things will spoil. So immediately after caucus, you should go for a joint meeting and try to settle there and then. Next. Now mediation phases and the task. Before mediation, initial contracts with the help of disputing parties to the preliminary meeting solution, promote mediation, communication, clarify issues, create options, reality test, confidential. So these are the things you have to first promote mediation in communication. So the opening statement of a mediator is to describe himself that I am your facilitator. There is it is a voluntary the process. You can walk out of the mediation at any time, and there is no the settlement will be voluntary. It will be decided by you. I will just help you to arrive at a solution, the conclusion or then agreement. And if there is any conflict of interest, mediator must at the preliminary stage itself tell their parties that I had appeared for this party, I had appeared for that party, etc. So he has to promote mediation, communication. He has to clarify the issues between two parties. generate options. Generating option is must for a mediator. Reality test, I mean, whereas I caucuses, you have to test the realities. You have to keep it confidential. Disclosure should be with the consent. Now, opening phase, there are how many phases? Opening phase, problem defining in opening phase itself. Middle stages, there are negotiations, and this is very critical, middle stage, and dispute solving, final game, and reaching at an agreement. So, as I said, mediators opening statement, parties opening statement, this is the process. This is in the first meeting, and summarizing and limiting topics in the first meeting. Then you will identify the issue, redefining the issues if necessary, reframing the same, generate possible solutions at the options, private meetings between the mediator and each party, further private and joint sessions if necessary, and the agreement signed by both the parties and the mediator. This is the the entire process which is not there in the act, but this is what is the custom and the process followed by a certified mediator who are trained mediators. Next. Now, I explained to you regarding the whole process of mediation. There are phases before mediation. Mediation starts, opening phase, problem defining, middle stages, negotiation, dispute solving, initial contacts with the disputing parties, preliminary meetings, mediators opening statement, parties opening statement, summarizing and limiting the topics, identify the issues, redefining the issues if necessary, reframing same, generate possible options, solutions, private. Now, I will tell you on this also how to redefine and generate possible solutions. There is a established guidelines or a custom process followed by every mediators in the mediation. I will come to that in the next slide. Mediator's task, help party to arrive at a solution, promote communication. You should try that both of them, they speak with each other, because they are, carrying a lot of baggages of negativity. Once they carry that baggage is reduced, uh, there are chances of settlement. If you have seen, there are movies, Hindi movies like Namak, Bawarchi, and there is one of Govinda where he tries to resolve dispute between two brothers in a joint family. You must see that was a best acting of Rajesh Khanna, where he becomes a Bawarchi and he tries to reduce the disputes between the two brothers, and they all start living happily. So this is how a mediator has to act. So he has to clarify the issues, generate options, reality test, confidential, and the disclosure. Next. Now, role of a mediator, he is a party advocate mediator, introduces each other. As I said, mediator plays a role of host, as if both the litigants are your guests. He must avoid situation like being seen by those who last arrive, having socialized too much with those who first arrive. That is why we always say that all have come, then we join the process. So there has to be 3 rooms rather than so you go then subsequently in a conference room after all are arrived. So you should not be very cozy or friendly with the party who arrives first. Now, purpose of mediator opening statement to inform the parties about the mediation process. So they are new, they are, they don't know what is mediation. So you have to apprise them with the process of mediation. It has to be private and confidential. You have to tell them this is private and confidential. This is informal. No transcript. Mediator don't write anything. clarify the role of the mediator in contrast with the role of an arbitrator. This you need not, arbitration at that particular section is. So caucus procedure, he has to inform the parties that he has no power to decide, like the judge or an arbitrator. So no transcript means nowadays we do prepare, minutes. In if the stake in the matter is very high. And another thing is we avoid the presence of any lawyers in the mediation room, because it is the parties who decide and not the lawyers. So as a mediator, if you take up any matter, keep this in mind. Next. Now, so to commence and develop the credibility and trust relationship with the parties, uh, between a mediator and parties and counsel, you have to start, talking to them, and to assure the parties of a safe and secure environment of a negotiation. You have to say that this is informal, this is voluntary. Whatever you decide, I will give you an option. I will not decide anything. You have to decide what is good for you. And I would only say that it is better that it is resolved. To gain commitments from the parties, all the agents and representatives of the parties have adequate discretion, authority, and information to resolve the dispute. This you have to inform the parties. Participants have adequate time. Participants will hang in with the mediation. All participants commit to give their best good faith efforts to resolve the disputes by agreement if possible. All people will keep confidence of these proceedings. This is what the first meeting you will inform the parties. Next. Now, mediator disclose and consent of each party to the process of mediator promises to disclose fully and truly all the relevant facts and supporting document evidence that are relevant to the mediation process. So, mediator's disclosure and consent of the parties. So, he will promise that these are the facts and the documentary evidence. He will say that he is how qualified he is, and he will say that he is a neutral person and he will not take sides. That is why very first meeting you should not be very cozy with any of the parties who arrive first. They have their own psychology. देखा वो उसके साथ में कैसे बात कर रही थी, तो वो पक्का फ्रेंडली होगी उसके साथ. So you have to avoid that. If you do that, mediation will not be successful. Next. Fairness is the mediator's responsibility. Parties have freedom to agree. You have to inform them that I will be fair. They may please mediator being a neutral party decides nothing and advises as to nothing. Mediator is not a counsel nor an advisor. The mediator is a neutral person, and this neutrality extends not only till death, but also after the mediation is over. Confidentiality is the vital phenomenon of a mediation. The evidence that is discoverable and admissible at trial, had the mediation not been held, does not lose its character as a discoverable at the trial merely because it is used or disclosed as a mediator is at very you can say test acidic test that confidentially he should not tell anyone what was revealed to him. So this is must and mandatory character of a mediator. Then only people will trust you as a mediator and not otherwise. Now, opening statement of a mediator. As I said, that you have introduced yourself, and then parties will start pouncing against each other. Their ventilation, this is a ventilation point. So they like to ventilate their baggages, exercise, let them let off, whether it is wife or a husband, let them let off. and you have to say that at least maintain the dignity and honor of all the people present in the room, but let them say whatever they want to say. Try to judge, not judge. Mediator is not a judge, but to think that what is the real issue between the parties. So in opening statement, one person will see the number of outbursts of the parties. These outbursts will help in resolving the matter. It is psychological status once the mind is opened against whom the person has agitation. The other person also evaluates himself and his mistakes, and it can be said that the opening statement will dilute not only the differences but negative impulses and ego of each party. In this process, commonly in joint session, the parties can be taken to caucuses immediately after mediator's opening statement and the party's opening statement. 3 or 8 minutes for a party are opening as required. So you take whatever you want to after the joint meeting, you take them to caucus and let them vent out and tell you the truth, because when they are alone they will tell you the truth, not otherwise. Thereafter, mediator asks the party who will start first. I have already discussed this. Usually, in the case of court-referred mediation, the party who has approached the court, that is the plaintiff, in the suit or a petition or an appellant, will prefer to start first. In case of party who has not responded to the last settlement offer or the claimant there has been no offer, mediator can select the party to speak first. The party or the counsel decides. It is courtesy of the attorney, counsel, barrister, solicitor to suggest a mediator that and decide how much he will speak. We see nowadays there is a live telecast of conduct of hearing in the Supreme Court where Honorable CJI says how much time you will take, Mr. Counsel, and the time period is allocated. So similarly, you have to see that how much time you will speak to one party, and accordingly it is decided. When the client is articulate and not emotional, it is advisable to show him as a good witness. But when the opening of whatever fashion is concluded, the mediator can then ask the client questions like, are there other things would you like to talk about? Do you want to say anything more? So, next. You have to make a checklist as a mediator and confirm you have complied with all. Is you have to ask the parties. See, this is all not there in the Act of 2023. I'm just giving you a brief outline of how to conduct a mediation, because there is no particular law or guideline or what you can say that rules how to conduct a mediator, but this is international system or the custom how to conduct a mediator. So it is a sort of a small training to those who are listening to this lecture. Now make a checklist. Is there anything you would like to add? Ask the party. How do you feel about this? Do you feel relaxed and the baggages of complaint you were carrying is lightweighted or not? Where the level of adversity is high, this is usually between husband and wife, and when the parties to the dispute are commercial parties, the test of a mediator to make them discuss their own points of agitation, talking directly to each other about their areas of agreement, the points and the areas of disagreement, their perception of other parties to the mediation, alternative business deals they may think to arrive at the end to resolve the disputes independent, objective, standard criteria. Make this checklist if you are a mediator. Now, the mediator may decide prior history of settlement negotiations with the parties. The mediator may ask for a copy of key evidentiary papers, if any, which are relevant to the discussion and mediation process. As we said that it's an informal and uh, there is nothing in writing, but certain evidentiary papers are there. It is good to sometimes husband and wife will say, उन लोगों ने मेरा ज्वेलरी ले लिया है. So you have to ask any photos, bills, and then ask the husband, ये बोल रही है कि आपने ज्वेलरी ली है, कहाँ पर है, कौन से लॉकर में है. तो this is how you have to conduct. Like when there is a dispute for jewelry and divorce matter. Counsel and parties tend to open to the mediator during this opening statement, out of which the mediator will pick up the areas of dispute or ask questions as he needs that the party opening first should address directly to the adversary. Not to curse them, but to establish a respectful relationship with them and pursue them. After all, they are the people with whom a party must reach to an agreement. I don't want to say something which is negative, but usually differences between husband and wife is created mostly by uh, mother of the girl. In one of the case, uh, they control daughter's life on the phone, and husband was very much irritated that he said that my mother-in-law is controlling my life on the phone. So these are the small things which you have to during the negotiation uh, you have to take care of it, and you have to make a girl understand that even he has his privacy, he has his own identity, and you have to respect it. So as a girl, one must understand that how to keep their matrimonial life safe. So now going ahead, during this session, mediator must gather, the first session, mediator must gather more and more information as to general facts, the status of parties to the process and their positions. He must also consider legal issues and arguments led by the parties in the opening statement. After listening to one party, he must communicate what he has understood completely to complete the loop. This will build trust in him and also confidence. Similarly, he has to listen and complete the loop with the other party. The action demonstrates neutrality and understanding of a mediator and his balanced involvement and detachment. So you have to, once again, I mean, if it is money involved or the marriage involved, you have to take care of these issues. Confidentiality and trust is to be built up. Fees of the mediator, if it is through Bombay High Court, it is provided there. And before starting with the mediator, you should fix your fees. But if it is a senior counsel and stakes are high, those fees are very high. But in other cases, fees are fixed by the mediation center. The intention to fix the fees to avail the resolution of dispute at a reasonable rates. Now, Russell on arbitration in its 20th edition has stated regarding exorbitant fees as where an arbitrator or an umpire demands payment of his charges before delivery of his award, any party to the reference other than the party who has agreed to those charges in writing with the arbitrator or an umpire may pay into court amount of charges and then apply to the court for an order that the award be delivered and arbitrator's charges to be taxed. It would seem further that a party who has paid exorbitant charges in order to obtain delivery of an award may recover the excess beyond what is reasonable in an action against the arbitrator for money has and received. There were in between, many petitions were filed for non-payment of arbitrator fees because it was exorbitant. So many petitions were filed on issue of fees. Next. Mediator should always be positive and enthusiastic. That we will certainly settle, don't worry. And commitment is important for a mediator to summarize his commitment in his opening statement to get the parties and lawyers. Now here, as I said, that there is a process of generating option. Bhatana, Vatana, and Malatana. These are the three international basic principles to settle the mediation. It is not in India only, and every international players of mediators, they follow this system of Bhatna, Vatna, and Malatna. So what is Bhatna? The best alternative to negotiated agreement. Vatna, the worst alternative to a negotiated agreement. Malatna, the most likely alternative to a negotiated agreement. In any agreement and in a method of negotiation, three criteria must be considered. It should be produce a wise settlement term if an agreement is possible. It should be efficient and it should improve or at least not damage the relationship between the parties. So this is very much important for a mediator to conduct a mediation, that the relationships are strained, but see to it, it is not strained more because of a mediation. Next. Now I will explain to you what is Bhatna, best alternative to a negotiated agreement. This term was developed by Roger Fisher, William Ury, and Bruce Patton of Harvard Negotiating Project. It means you negotiate to get something from the other party or person that is more valuable to you than the other party. In such a case, you will get the best deal. Now, I will give you a simple example. Okay. So, simple example, the target set loan. Now, since we are short of time, we will go fast. Next. Worst alternative negotiated agreement is with interest again Mr. X for amount of ₹100. You incur expense of 25, but there is no immediate relief granted to you in the suit. Other creditors of Mr. X, considering your business relationship with him, offers to you immediate payment of 100 without interest, and this is what is worst alternative negotiated agreement. Prior to Act coming into force, mediation was not appropriate for the parties who refused to negotiate. The party wanted third party to adjudicate the case. The party wanted guarantee of a final binding decision. Party wants a public hearing on the dispute. Party wants to establish the legal precedent. Party does not have sufficient information or arrive at realistic liability or damages and delay in resolution. Now, this is also coined in the 2023 Act. And there are schedules, so you can refer to those schedules. where the arbitrations or mediations are appropriate or not appropriate. Next. So yeah, these are the, it is in the schedule where mediation is not allowed, and the crimes which is not non-compoundable, where there also there is no mediation. Next. Okay, we can go ahead, ma'am. This was the question from Mr. Patel. The Commercial Courts Act for mandatory mediation by applying for urgent relief under Section 5. There are two Supreme Court judgments, Yamini Manohar versus TKD Kirti. It was held. It is difficult to agree with the proposition that the plaintiff has absolute choice and right to paralyze Section 12A of Commercial Courts Act by making prayer for urgent relief, camouflage and guise to bypass the statutory mandate of pre-litigation mediation should be checked when the deception and falsity is apparent to establish. The proposition that the commercial courts do have a role, albeit a limited one, should be accepted. Otherwise, it would be up to the plaintiff alone to decide whether to resort to procedure of 12A of CC Act. An absolute unfettered right approach is not justified if the pre-institution mediation under 12A of the Act is bypassed. There are two judgments on this, and another is of Patel Automation Private Limited versus Rakeja Engineers Private Limited. Next. Mediation can be terminated at any stage, and there can be a replacement also. So it is provided in the Act itself. Next. As I said, it can be replaced on termination of any mediator, mandate of a mediator. Settlement agreement, if settlement is arrived at, it has to be signed by both the parties and the mediator, and it has to be given to the court or the appropriate authority. If there is a transfer of property in the settlement agreement, it requires stamping and registration as per the appropriate law of stamp duty and registration. A challenge to the mediator's settlement agreement is there is also a judgment. It is difficult to challenge unless there is a fraud, corruption, impersonation, or mediation was conducted in dispute, or matters was not fit for mediation under Section 6. In only those cases, settlement agreement can be challenged. An application for challenging the mediated settlement agreement shall be made after 90 days have elapsed from the date on which the party making application has received the copy of the mediated settlement agreement. And provided that party can say that I was prevented by sufficient cause, so that beyond 90 days he can apply for condonation of delay, and it is in the discretion of the court to condone the delay as per the facts and circumstances of the case. Limitation Act is there on any time being in force in computing the period of limitation fixed for any proceeding relating to disputes in respect of which mediation is undertaken under this Act. The period from the date of commencement of mediation and end of it is to be excluded. There are certain pictures. If you all permit, can I show some body language?
Sure, ma'am.
Yeah. It will take another 5-10 minutes, not more than that. And how to read a person's face and the behavior. Because this is a training session, or you can say that the basic fundamentals of a mediation. Uh,
Is there any difficulty?
Difficulty in where?
You're presenting something, right?
Those pictures of Prime Minister.
You want us to do it? Should we do it?
Can you?
Yes, yes, yes.
Yeah. Yeah. Now, see this picture. Mediator has to read the face. So from this picture, what you get to see is this is our Prime Minister. His eyes are deep inside. There is a worry on his face, and he is searching some answer, and he thinks that what will be the future of my country, citizens of India. We can read so many things going on in his mind, and this was during the corona period. Okay, so we can really see the worries and the questions, and he's searching for some answers. This is how a mediator has to read a picture. This is called psychology and body language, and every mediator must learn that. Yeah. In this picture, what we see is trust. They enjoy each other's company, and they trust each other, and very friendly relations they have. This is another body language story. And the third, see, in this, he is trying to understand his mind, and his eyes, he is not contacting our Prime Minister with eye to eye. There is no eye to eye contact. And he is also trying to learn from his facial expression what is there in the mind. These are, basic three things. One is to, learn from the facial expression of a person as a mediator. That's all. Thank you so much. I have exceeded my time limit, and I apologize for the same. But I think, I hope I have given the best what you needed as a training session.
Thank you, ma'am. I now call upon Akash for the vote of thanks.
Thank you, ma'am, for your uh, kind words and explaining the Mediation Act very well. Your insights on the Mediation Act has really helped us, and we hope that it will enhance the knowledge of all the participants present here. Thank you.
Thank you.
Thank you so much.
Thank you.